research to you related to technology policy. There's a lot of fantastic work being done in India and outside of India, but quite often research gets only consumed and read uh, by researchers who are looking to build upon that work or are looking to respond to certain work. So we thought that some of this great work should make it to people who are not necessarily looking uh, to read uh, you know, vast amounts of text on a particular piece of work, but allow them to get the gist of it, allow them to understand what's going on and what recommendations are being made, because technology policy is a very fast evolving space. So we hope that this is the first of many, and we will bring many more such talks to you. Very pleased to introduce two friends, Shashank Mohan and Divij Joshi, who've just earlier this week released a draft law for governing digital health surveillance, including Aarogya Setu and contact tracing in India. Um, and we wanted to understand what sort of recommendations they've made for this draft law that they've created. I'd like to first invite Divij to introduce us to this work. So the format is that uh, we'll do 30 minutes. Divij and Shashank will introduce their work in the first 30 minutes, and then we'll open up for questions. For those of you who are participating on Zoom on this call, please do use the Q&A to share questions, and we'll bring you in. Divij, over to you.
Thanks, Nikhil. It's always a pleasure to be a part of a Media Nama event, and it's an honor to be a part of this first inaugural Media Nama talk. And I think it's really important for us as well to get feedback from everybody who's attending this talk or who's watching it. I'm just going to post a link to our report and the draft legislation in the chat here for everybody to view. And we'll kind of also be guiding you through our recommendations as well as the bill. So I'm Divij. I am an independent lawyer and a policy researcher. I'm currently working in a few capacities, particularly as a Mozilla Tech Policy Fellow for this year, where I'm looking into artificial intelligence and policy in India. And I've drafted this in my independent capacity, not as part of this project, but with my colleague, Shashank. Shashank, would you just like to briefly introduce yourself?
Hello, everyone. Thanks for joining this discussion. I'm Shashank Mohan. I've been a tech policy researcher for more than 2 years now. And I currently am working with the Center for Communications Governance at the National University, Delhi. But again, as Divij mentioned, we've sort of done this research in our independent capacity. And yeah, I'll just let Divij do the introduction.
Thanks. I'm just going to share a few slides to take you through the content of our recommendations and the bill. Hopefully make that a little easier. So I don't want to spend too much time kind of introducing the problems, with Aarogya Setu, and we're all already familiar with kind of, we've had a lot of discussion around surveillance and privacy over the last few years. But regardless of that, the moment this pandemic came in, our immediate solution was to throw like mass surveillance at it. And I think that that's a problem, right? And while we've kind of focused a lot on issues of data protection and data security concerns, and we've had Elliot Anderson talking about all of this, and there's been a lot of discussion around it. I don't think the legal community has managed and there have been kind of like litigations in various high courts and kind of efforts to try and regulate this, but it's still sorely lacking, right? There's still a legal framework. There's an absence of a data protection framework. There's an absence of an adequate epidemic disease regulation or law in India. We're still using a law from the 1800s. So we thought that it's necessary to put forth kind of the best practices of what a legal framework for the governance of these technologies can look like. How do we make these technologies more democratic? How do we kind of make sure that there's transparency, accountability, and rights for users of these technologies and rights for citizens built into the law? So that's very broadly been the focus of this exercise. And I think what we've done essentially is to incorporate our recommendations in the form of the draft Coronavirus Digital Technologies Act. which does three things very broadly. It establishes rights and safeguards for privacy and data protection and against technology-enabled discrimination, and provides forums for redress. It also establishes clear and independent oversight of these technologies, including how and when they should come about and in what context, and how they can continuously be analyzed and, if necessary, kind of brought down or re-regulated. And finally, that there need to be rules and obligations around what standards of transparency and accountability any government body, particularly which is trying to deploy and develop these technologies, needs to meet. I will go on to Shashank, who will be explaining why we need to bring this new law and also standards of data protection and proportionality that we've assessed here.
So thanks, Divij, for that introduction. So what we've seen is that the kind of digital health surveillance and the general surveillance these apps have enabled is particularly relevant to the pandemic and what sort of the needs of the pandemic being contact tracing, exposure notification, and immunity passports. And in regular terms, when we don't have the pandemic, these will seem very excessive from a privacy perspective. For that reason, we've sort of recommended a new law, as Divij has also pointed out, called the Coronavirus Digital Technologies Act. And we recommend that the government should pass such a fresh law backed by Parliament. And such law should first and foremost cover data protection principles. Other stuff like measures for transparency and accountability. It should pass the test of proportionality, which I'll be briefly touching upon. And of course, which is something missing right now, it is that it should have regulatory oversight and should provide for some accountability from the government. What we've done in the bill is sort of tried to bring in universally recognized data protection principles like notice and consent, purpose limitation, collection limitation, provide for erasure of data, provide for ease of sort of withdrawal of consent. We've also introduced a provision which sort of gives the guardian and the parent rights to give consent for children, which we feel was missing in the current sort of Aarogya Setu protocol situation. And we've also inserted language which makes Aarogya Setu and the law come in compliance with the tests of necessity and proportionality. Going on to the next point of the Aarogya Setu protocol. And sorry, I mean, before that, actually talking about proportionality, as I was saying before. Again, as we've said, our recommendation has been a law or which sort of will incorporate proportionality principles. But we feel that any technology which is enabling digital health surveillance should be proportionate and adhere to constitutional principles of necessity and proportionality recognized by the Supreme Court. Two key features which we feel are missing from Aarogya Setu when we sort of consider proportionality. Firstly, there being a rational nexus between the object sought to be achieved and the measure adopted here. The object being mitigation against the coronavirus in general, and the measure in this case being adoption of such technologies like Aarogya Setu. We've seen various health experts talk about how digital contact tracing has its own error rates with, and specifically Aarogya Setu using Bluetooth and GPS technology. Experts have talked about how Bluetooth range is an issue, how sort of GPS and Bluetooth have their own error rates, and a lot of reliance can sort of not be placed on these digital contact tracing technologies, and they should always be used as a sort of secondary supplement to physical contact tracing and testing. So we feel that the government must really explain this nexus between how between a use of Aarogya Setu and such technologies and the mitigation of the virus. The second measure under proportionality, which we feel that Aarogya Setu specifically misses, is that the government must show that this is the sort of least privacy restrictive measure which they could have adopted. And we again feel that Aarogya Setu sort of fails specifically on this test, because even if you look at other recommendations from around the world, I can give an example of the Australian COVID app, and it does not sort of collect location data. It does not collect specific age. So the kind of gamut of data collected under Aarogya Setu, demographic details, location data, um, gender, profession, travel history, health assessment data, all of this we feel is pretty excessive. And the government must show that these are apps, all these categories of data are absolutely necessary. And there is no way that for them to collect lesser data and also achieve the sort of same measure of mitigating against the coronavirus. So we feel that, we've been seeing how there is a lot of confusion around the mandatory voluntary sort of um, 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 nature of this app. Is currently still people who are living in containment zone, or are in self-isolation, have to mandatorily download Aarogya Setu. So for this, especially this mandatory nature, it is essential that the government show how Aarogya Setu passes the test of proportionality. Um, Going on to the sort of next point here, um, um, Divij, can you sort of change the slide?
Yeah, can you see the slide? I changed it.
Yeah. So, going on to the Aarogya Setu protocol and the details of that. This was brought in around 11th of May 2020, around 1 month after the Aarogya Setu app went live. And we feel that, firstly, this should be replaced by a proper law, as we've suggested. Or in the alternative, if a law is not brought in, all the sort of data protection principles, transparency measures, and accountability measures which we've suggested in the language of the bill should be incorporated within the Aarogya Setu protocol. It is essential to point out to the fact that the Aarogya Setu protocol cannot be considered a law. It is it is in the form of at most an executive notification by the Ministry of IT, and it does not incorporate proper principles of data protection, specifically purpose limitation and collection limitation. If we read the definitions of, let's say, appropriate health responses, which sort of allows the government to collect data for that purpose, it is very broad and vague as per the Aarogya Setu protocol. We believe that such phrases like appropriate health responses, third party, and strictly necessary should be sort of well defined under the protocol and limited. Currently, the protocol allows for data sharing by the government to third parties. We don't know who these third parties are, and they say that it can be shared with third parties when strictly necessary. We don't. It's not clear what they mean by strictly necessary right now. We also believe that the Aarogya Setu protocol should adhere to the standards of necessity and proportionality, which I just covered. Specifically, if sort of a new law is not brought in, and it does not cover the language we've sort of recommended in our draft sort of law. Now, I think Divij will be covering topics of exclusion, transparency, and accountability, and he will go a bit into certain provisions of the law as well.
Thanks. So as Shashank already mentioned, one of the biggest problems that we've seen in the implementation of all of these technologies has been one where the government hasn't even considered issues of technological exclusion. And this is fairly apparent from the broad mandates for making these technologies mandatory, for saying that everyone from office workers to construction workers to people in containment zones must have this at the risk of facing penalties under section 188 of the IPC. And we think that the kind of this both impinges on a fundamental principle of voluntariness in the adoption of these technologies, which is also linked to kind of how trustworthy these technologies are seen by the public. But more importantly, it leads to the detriment of individuals and citizens for no fault of their own, right? Because a lot of people don't have access to smartphones. A lot of people don't have access to stable internet connections or even, reliable power lines in order to charge their phones. And to punish them for something such as, for being excluded by technology is completely illegal and unconstitutional in our view. We think that this very fundamentally impinges upon, like a classical Article 14 test against the right of equality by creating a totally unreasonable classification between people who have these technologies and those who don't. So what we've recommended, and this is on the lines of proposals as well as established laws in other jurisdictions such as Australia and the UK and the US now, is that there need to be specific protections against technology-enabled exclusion and discrimination. This has to be both against the government, which is kind of mandating conditions as well as penalizing people for not having this application. So the first is that there should not be any sanctions in terms of criminal or civil consequences for not having the app, even if you're a worker, even if you're living in a containment zone. That needs to be a fundamental principle which is established in Section 5 of this Act. And there also, we need to roll back the kind of conditionality that this app is creating, or that these technologies are creating a precedent for, right? You need a green code to travel on the Bangalore metro. That is a fundamental, that's an infringement on your right to kind of movement and association, with no particular reasonable basis, right? So and this extends also to private authorities or private private goods that are important to the public. It's important for all of us to access, but we are unable to access them because even people like banks or other kind of say app-based delivery workers are being made to download these applications as a condition for fulfillment of contracts, as a condition for access to services. Given that we don't have a comprehensive anti-discrimination legislation in India, something that's been relied upon in similar situations, for example, in the UK, we need to establish these rights under a new legal framework. We need to tell people that, especially given the kind of government messaging that has gone out saying that this app is actually going to lead to a bridge to health or whatever, we need to establish that you cannot be discriminating on grounds simply because people are unwilling to download this or use this technology, or don't have the capability of using this technology. The other important area of concern, I think, has been the way in which this technology has ultimately been deployed. All of us know very, very little about what this is, both what it does, how it operates, and what it's intended to do. Because unlike in other jurisdictions, there have not been any comprehensive studies about how Aarogya Setu or how digital contact tracing, exposure notifications, or health codes are expected to work in the Indian context. As I already mentioned, a lot of people, I would say close to 60% by most recent estimates, don't have access to a smartphone and don't have access to mobile internet. So in this context, how are people expected to participate in this kind of a mass technological experiment, right? That kind of communication has not been forthcoming. There have been no models or projections by the government about how this technology is expected to work, what kind of numbers they expect to achieve, and what kind of public health benefit it seeks to establish. So there need to be enforceable obligations for transparency, both in terms of how and why this has been procured. We've already seen how the involvement of private players has led to, again, a breakdown of trust between whether or not we should use this technology. The fact that it's been deployed without any forms of public procurement, that has been done by volunteers, and we don't really know who to hold accountable for all of this. So there's been very little transparency in the development. Even when the government released the so-called, like, opened up the source code, there have been several problems with that. Firstly, we don't know if the source code that's been released is the actual one that's running on the app, because it doesn't use forms like reproducible builds which can assure that we're using the same source code. But more important, simply source code transparency is very limited in many ways, right? Firstly, this is only the SDK source code, which gives us very little information about how the app actually works. Most of the processing for the app, for example, the fact that you're getting an orange or yellow source code, orange or yellow health code, which is determining how at risk of coronavirus you are, is something that is processed at the central level, right? We don't know how this processing is taking place. We don't know whether it's secure, and we don't know whether it's legitimate. What if they're just using random things like unscientific information to determine whether or not you're at risk of coronavirus? And this kind of notification that they're giving people has tremendous implications just for how we want to assess ourselves in terms of how healthy we are and what risk we pose to others, but also how others are perceiving this information, right? Because we're required to show Aarogya Setu health code to a metro employee or before we access a flight. So all of these considerations are incredibly important from a transparency point of view. And unlike again other implementations of these technologies across the world, I think there have been things like the Blue Trace Open Protocol, the DP3T Open Protocol, which establish very clear, which basically open up how this communication between various devices and various actors in such a system work, right? So it establishes that this is the kind of Bluetooth signal that's necessary for this to work. And this is how the Bluetooth functionality will work. This is how it will determine a contact event. We don't know any of this in how the Aarogya Setu app particularly works, as well as many of the other apps that are in development by various states in India. So unlike in other countries, there is no open application communications protocol which tells us about the very specifics of each actors and the communication channels that are used. And we can't assess it for its scientific validity as well because of this lack of transparency. So the two kind of major provisions within our draft law are that under Section 8, we've said that the government needs to publish documentation relating both to procurement as well as, under Section 7 about data protection, about who this information is being shared in and the entire network and ecosystem of actors, but also publish both the source code of the SDKs or the applications, as well as the server-side source code, which enables people to understand how this is working. Publish open communications protocol about the functioning of this system and how it can be replicated. And also, more importantly, I think it's also necessary for this all to be communicated to users of the technology itself, right? Because if they don't know how it's going to work, then they won't be able to assess it for themselves or even understand whether it's functioning properly. So it's really important to have open scientific communication between the government and the people who are expected to use this app as to why it works and why it's necessary for them to, instead of just relying upon the fact that the Prime Minister has said so or Niti Aayog has said so. Section 11 again does something that's a best practice around the world in terms of data protection, but we've kind of expanded it to include a technology impact assessment, which basically means that the technology needs to be trialed and the technology needs to be assessed for any kind of the risks that it poses to the various rights established or the various interests that people have in using these technologies. And based on that impact assessment is when any sanction or when this technology should be carried forward, right? So we've seen data protection impact assessments in other contexts, which look at the risk that this poses to privacy, but we think that because this also poses risks to individuals' freedom of movements or things like exclusion and discrimination, those also need to be incorporated into a more comprehensive technology impact assessment, which is provided under Section 11 of our draft. And finally, I think it's important to talk about what kind of accountability structures can exist for this. We've currently seen that we only know that NIC is largely responsible as per the protocol for the oversight of this, and that the protocol also kind of mentions that there will be an audit and review, but doesn't give any kind of comprehensive, it doesn't tell you when this audit is going to happen, what the implications of that are. Does it mean that the technology will stop being used once the audit is given? So what's necessary for us to do here, therefore, is to establish independent oversight mechanisms and also mechanisms for redress, right? The protocol kind of hinges any form of redress. Firstly, the privacy policy does not provide for any kind of redress for affected users. And the protocol hinges any kind of individual redress on the Disaster Management Act, which forecloses your right to directly approach a civil court, an ordinary civil court, for redress of your grievances. What we've done, therefore, is to kind of try to establish both an independent oversight mechanism as well as allow or explicitly allow people to access various forums for redressal of their grievances. And I think like in jurisdictions like the UK as well as in Canada, it's important to have independent oversight responsible for both sanctioning how this technology works, which is to say that nothing should be experimental technology should not be deployed at least without trialing them or having an assessment of how they're supposed to work, and then continuously assessing them to see whether they're meeting their stated objectives. So we think that an independent oversight board, one which is truly independent in that it's not setting the rules, it's not both setting the rules and enforcing them in the way that, say, the NIC is currently doing, but it's responsible for oversight of the executive agency, which is responsible for developing and deploying this technology. And we think that, so under section 9 and 10, we've basically established what such a board can potentially look like, what kind of actors it should contain for political legitimacy, and under section 10, what kind of powers it should have to rein in the use of this technology and to ensure that there are appropriate safeguards. In sections 12, 13, and 14, we've also provided for, given that we have specific rights against exclusion, specific rights for data protection, that there need to be appropriate forums where this can be redressed, and there need to be appropriate penalties for any violation of these kind of obligations or rights that are under the bill. So we've provided for that as well. And we think that independent oversight is one way towards achieving this form of accountability that's necessary for us to know that mass surveillance isn't simply happening for the sake of it, that there's actually some kind of public benefit coming out of this act, and that there's some kind of democratic control over these technologies. So that's about a very broad overview of this law. I think we'll spend the rest of the time here just kind of answering questions and getting feedback on this bill, because this is still very much a work in progress. We very much want to develop it. It's kind of a best practices. We think that there are many forms that legal regulation can and should take, as Shashank already mentioned. One such form could be improving the protocol. One such form could be, say, putting rules under specific laws, although we will have to see whether that still meets the required obligations of having a anchoring statute. But we think that this is not just necessary for kind of Aarogya Setu, right? We think that even state governments who are hoping to deploy these kind of technologies need to have a framework for what effective and democratic governance can look like. So when the Kerala government, for example, last week put out like this 2-page document about data security, and there's been a lot of kind of conversation around that, then they also need to be thinking about like this broad overview of considerations that we've tried to highlight in our bill. So over to Nikhil to maybe moderate and receive input from the attendees.
Thanks, Shashank and Divij. So I have a few questions of my own before I go to the questions here. Firstly, what happens if this app becomes completely voluntary? That addresses one part of your key concerns, right? So what if Aarogya Setu becomes completely voluntary?
Yeah, I'll just very quickly, and we've kind of addressed this as well in our report, to say that voluntariness, firstly, from a constitutional perspective, there are two aspects, right? So firstly, the Constitution prohibits conditionalities, to say that, you have to forego your right to free movement in order to have a government service. So that kind of conditionality isn't considered voluntariness, and therefore will still not be considered like purely voluntary. But the other thing is, and the EU has already kind of, when you're thinking about the GDPR in the context of the governments using data collection and processing technologies, experience from the EU at least shows that it's always more helpful to rely on specific legal grounds and statutory grounds for the power of the government to do this, because voluntariness is very conditional, very contextual, right? It depends on what context you're collecting information in. And in this context, there are two particular problems. The first is that this is a government-citizen relationship, right? So there's already an inherent kind of deficit or power imbalance between the two actors in this situation. And the second, the context is that we're in the middle of a pandemic and the government is pushing an experimental technology in a humanitarian context, right? There's been a lot of work done about what ethics in humanitarian context looks like. And that, you can't be like, I will give you food if you give me all of your data. That's considered completely unethical, which is why voluntariness is kind of an incredibly tricky subject to broach here. So the best practice, I would say, maybe from a legal analysis or constitutional analysis, it may still pass the threshold of proportionality tests, but as a best practice, as an ethical practice, there still ought to be kind of a specific anchoring legislation and adequate safeguards. And Shashank.
Yeah, just to, we just mostly covered our points on if it's voluntary, but just to add one point, that voluntariness is moot here, right? As Divij also mentioned, in a pandemic where the government is saying, hey, you must download this app, it will help us sort of gather data. There's a sense of responsibility which citizens will also feel, and towards helping the government manage the pandemic. And when we talk about pure voluntariness in this situation, it goes for it goes out of the window in this case. And that's why we've recommended in our bill language, we've recommended specific provisions for purpose limitation, collection limitation, which will sort of strengthen the way this data is collected and how much of it is collected.
So, but the government can argue that is there a need for a law, because this is an emergency situation. They have to focus more on acting and trying to contain the spread of the virus. Parliament is not in session. So, is there a need for a law right now?
Yeah, and I think this is where we need to look at what is happening in other countries as well. There's already been laws in countries like the UK and Australia. I think in the US also they are considering a law. And we have to go back to the point that what experts are saying about digital contact tracing in specific, right, and how useful or effective even that is. So and especially if you look at this app was launched in April. And we're sitting in July now, and the government has sort of not moved on any instance on whether this needs to be backed by a law or not. So in this case, we definitely feel now is the time to bring out a specific legislation. And Divij, if you want to add something.
Yeah, I mean, of course, Parliament is not in session, and that's a big worry here. And we don't even know when it's going to be in session now, because all kind of democratic institutions seems to have stopped, and they're claiming emergency, right? But you can't always claim emergency for everything that you're doing. At some point, there needs to be, we exist in a democracy for a reason. There need to be institutions that are functioning. In this specific context, one thing that could play out better, Vrinda Bhandari and Faizal Rahman in their kind of analysis of why we need a law have also recommended this, that there could instead be an ordinance. We understand that rule by ordinance is obviously somewhat problematic, but when Parliament is not in session, an ordinance is obviously reviewed post hoc, and for an emergency situation like this, if they can put out a protocol, certainly they can put out more binding legal obligations as well.
So Shashidhar KJ has a question. He says, would this also cover apps and services which issue e-passes? Especially given that there is a strong case that there will be a second wave. And to add to that, my question is, does this also cover, for example, tracing of movement of quarantined patients using cell tower triangulation, which seems to be happening as well?
So we've limited the kind of technologies that this applies to, and we've defined it under Section 2 of this draft law. And the reason for this is that, ideally, you don't want to make something legal which should be patently illegal, right? Simply passing a law doesn't mean that surveillance of pervasive surveillance of individuals can be justified at any measure. So, and that's also kind of why the protocol is insufficient, because it doesn't define the purposes for which this is going to be used. But the three legitimate purposes that we actually see that, might be useful in the context of this pandemic are contact tracing, which means that it needs to be used by public health authorities very specifically for the purpose of identifying who may be affected by and who may need healthcare resources. The second, exposure notifications, again, similarly for individuals themselves to take appropriate action based on information they receive about themselves and not shared with others. And health codes, which kind of are similar to e-passes, but are based on the automated processing of health information and location information. Right. So if an e-pass is based on, say, an Aarogya Setu green code, in that situation, this would be something that's governed by this law. But otherwise, if it's simply something like tracking people within quarantine, I don't really think that that's something that needs to be legitimized by a separate law.
So just to continue from that, Soumya Tiwari is asking about whether how does this draft bill protect privacy when, let's say, the Aarogya Setu app is made mandatory by private actors like employers? It may not have civil and criminal consequences from the state. What does the draft bill offer to stop that?
So I think, that's a very good question, because we thought about that, and we've specifically included a provision in our draft law which says that no one can impose the sort of mandatory nature, whether it's a private individual or the government, for citizens to use this kind of technology. And we've seen this, also happening in other countries. The Australian sort of law also has this provision where individuals especially, this is important from a private individual, private entity and private individual perspective, that they cannot impose the usage of these apps in that situation. Divij?
Yeah, section 5 and 6 of the bill specifically kind of deal with the fact that there shouldn't either be any kind of criminal or civil consequences for failure to use the app, and also that it shouldn't be a condition. It shouldn't be conditioned in specific circumstances. Obviously, you can't like wholesale regulate private people's use of um, technologies like this, but you can at least prevent, for example, it being used as a condition for employment contracts. You can say that it shouldn't be used to discriminate between people who would otherwise have access to a public space, or any kind of a space to which the public generally has access, like a bank or an ATM or a pharmacy. So those kind of protections, I think, are legitimate and have been provided for.
So you answered one of Shailesh Singh's questions. The second one is, did you consider the existing legal framework which could possibly regulate contact tracing apps, possibly the IT traffic data rules? And just a similar question, how does a draft PDP bill affect the law? Is there an overlap, or is there a need if the PDP is passed?
Yeah, I think, again, great questions. And I think what we feel is that such kind of surveillance, which these apps kind of indulge into, is very specific to the nature of the pandemic and the world we're living in right now. And they should have a proper sunset clause, proper end alongside the end of the pandemic. It is very essential. That's why we recommended a specific law. Yes, on the question of the PDP bill, we have looked at provisions of the PDP bill, the data protection principles recognized by the PDP bill in tandem with the GDPR, and have incorporated similar protections, in fact, more enhanced protections in our bill. For example, the consent framework for our bill is very sort of specific. The consent needs to be explicit, it needs to be specific, so which is sort of a more tighter provision in that sense. So yes, if that answers your question. Divij?
Yeah, I mean, again, see, this highlights what best practices in terms of regulation can look like. Two answers. Firstly, the PDP bill doesn't exist right now, or rather, it's not law. And secondly, even if it were, I would argue that the exemptions made for government use would likely not require the government to incorporate standards of data protection in any situation here, right? Or at least the kind of best practices of data governance. So,
yeah. I think specifically on the IT traffic rules, if you mean the sort of metadata collection rules, and they don't exactly provide comprehensive protection for in terms of data protection. And specifically targeting the purposes for which apps like Aarogya Setu are used, as Divij covered: exposure notification, contact tracing, and immunity passports. So that's why we've tried to address these three specific aims of the Aarogya Setu and build protections around that.
Shodhan asks that the bill suggests civil courts as the means for dispute resolution. What is the rationale for this, considering the delays and the hassle of traditional dispute resolution systems? And my question, in addition to that, is what are the penalties, specific penalties that you've considered?
So that was kind of tricky. And again, of course, like all feedback here is like very much appreciated. One problem, of course, is, yes, delays and backlogs are like the norm. They're the situation in India. In fact, most courts right now would not even be functioning. But there is no reasonable alternative, right? The alternative is, do you set up a distinct grievance redressal body, and then does that have kind of the legitimacy to make these judicial determinations? I think independent judicial oversight is always kind of the standard that you should look forward to or look up to. And unlike the DM Act, which kind of prohibits approaching an ordinary civil courts still very much do the job of day-to-day oversight of and kind of like adjudicating matters of rights which may have been violated. So which is why like we proposed civil courts. The penalties, we did add a penalties clause which would largely be in akin to kind of damages. The quantum of penalties, of course, is something again that can be a matter of much deliberation, but it basically needs to deter people from kind of, say, breaking good faith in discriminating against people, or providing sanctioning people for not using these technologies. That's been the main purpose of introducing these penalties.
So there's a question from Siddharth about something related to what a question you'd answered earlier. Um, would you consider a deeming provision similar to Section 59 of the Aadhaar Act, or is the intent to invalidate or existing implementations of contact tracing in India?
I think the intention is to give legal sanctity and provide safeguards from a procedural and a substantive perspective to existing digital contact tracing mechanisms in India. And that's why, we've sort of focused on digital contact tracing as one of the important prongs we've tried to address through our legal framework. So, yeah.
I would say that, if a law like this were to come into place right now, then there would be then Aarogya Setu would have to cease. Exactly. Unless there's a specific sanction provided by independent oversight board, yes. Unless they comply with principles, and including all of the laws that have been, or the orders that have been passed mandating it, would immediately be in non-compliance with this law.
Adnan Alam is asking about what is the principle under which you are asking for transparency. Is this because citizens are being asked to install it to access services or goods that they have a constitutional right to?
So I think I'd like to take up that question. It's a good question. Specifically, if you look at how this app was, or how Aarogya Setu was created, the kind of people who are involved in the creation of the app, there is a lot of opacity around this process. The Supreme Court has made it very clear that, especially when it comes to public, using public funds for procurement of such technologies, there needs to be some semblance of transparency. The citizens have sort of a principal right to know, where these funds are used, and sort of in a transparent manner. And that's why we feel, and we've covered this in our analysis in fair detail. The various judgments which have required the Supreme Court to be, which have required the government to be transparent about procurement in specific. So yes, and secondly, just talking about the general democratic importance of transparency by the government, especially imposing an app which they hail as something which will aid their mitigation strategies for COVID. I think it becomes extremely important for them to be transparent.
Yeah, just to add that. Sure. Sorry. So should I carry on?
Yeah, go ahead.
Just to add that this is not obviously something new. Section 4.3 of the RTI Act requires proactive disclosure by government departments of this kind of information. It's not done, which is why it's important to just emphasize it. This is not a radical new law imposing transparency obligations. Very much all of these actions need to be by default transparent to citizens anyway.
So Shodhan has a question about the oversight mechanism. This is what are your views on the ombudsman model found in many sectors, in addition to a more formal dispute resolution system, either by way of specialist tribunals or less procedure-oriented systems such as consumer forums? And I had an add-on question on the independence of the oversight board. How do you ensure that?
So that's a good question. Going on to the independence of the oversight board, and also taking a learning from, let's say, what the PDP bill also recommends on the Data Protection Authority, we've tried to ensure that there is, a judicial member, a member from the government, an expert. So it's like a good mixed bag of, for the oversight board, and it's independent from the government as such. And we felt that that's very important, considering that the oversight board which we've recommended will give sanction to the using the usefulness and the initial using of the implementation of these apps and these digital technologies.
Okay, so we have about 15 minutes left, so I'm going to be a bit quick with the questions and a bit quick with the answers, please. Just in addition to the previous question, Geeta Sheshu asks, does the bill have penalties for non-compliance?
It does. Yes. Let me just see which specific provision that is.
There is a penalty clause in the bill. So
there's a penalty clause
Okay,
under
so
section
let's
13.
move on to the next one. Shivangi Narayan has asked about what about data sharing with health sector apps such as Practo? If the government does it anyway surreptitiously, can we challenge it in the future? In what ways?
So what we've done is that we've ensured that any sort of third-party data sharing in our legal framework happens for specific purposes of digital contact tracing, exposure notification, and immunity sort of passports. And if you read this in tandem with the purpose limitation and the collection limitation of the apps, which is inbuilt in our legal framework, it sort of creates a bit of a protection around the abuse of sharing of this data arbitrarily.
Yeah, I personally think it's completely illegitimate to do something like this. Even sharing it with the health stack, which is kind of just been revealed to us, like, one day you wake up and you're like, oh, they collected information about how healthy I am, where I've been for the last 30 days and who I've met, and now they've decided to share it with this vague body called the National Health Stack, and we don't know what's going to come of it. Ultimately, the National Health Stack is also essentially going to be used for insurance payments and premiums. So that's a whole different problem. It absolutely should not happen.
Siddharth asks, could there be a mandate to notify the user if their personal data is breached? Is there a breach notification mandate?
I think that's a good suggestion. And we will take this up, I think, in future iterations of in notification of privacy breaches.
An anonymous attendee is asking about how the oversight board will decide, by simple majority or unanimity.
I think, we've sort of left the mechanism of the oversight board as in the current draft to be, decided by the board itself. And we can sort of add a procedure, for specifically addressing complaints. And that's, again, feedback well taken.
Yeah, I was considering this. We had initially kind of thought about maybe it should be by consensus of all members.
Yes.
With the chairman's ability to kind of override if in case consensus isn't reached. But yeah, specifically we thought like that's maybe something best left to regulations or more procedural matters under regulations.
A question from Brinda. Would this law cover digital health certificates, issue concerns, etc., given that the digital health certificates are coming up in a big way across the world? Will this legitimize the issue of such certificates like a passport?
Yeah, absolutely. I mean, that's our third prong alongside exposure notifications and contact tracing is immunity passports and sort of these health certificates. We've tried to address these broad three problems through our legal framework and analysis. Absolutely, but it will be covered.
Yeah, and just to add to that, I think the bigger problem. So inoculation certificates are already very much a part of both Indian law and international law. They kind of control who can fly where, who can travel where, who can all of that. That's not something we want to get into the weeds of. We're not scientific experts on what constitutes a proper immunity passport. But if there's like automated data processing works, and this is very specific digital technologies, that there's multiple points of failure, multiple actors, and multiple kind of when you're pushing notifications to an end user, there can be multiple problems with that. So to that extent, digital health codes and what we've linked it with is kind of this idea of immunity passports is what should be regulated from the perspective of data protection exclusion and technological exclusion.
Right.
Otherwise, we don't really want to go into when is an immunity passport legitimate, when it's not, kind of outside the scope of this particular law.
A follow-up question from Shailesh Singh. Would you say existent provisions under the SPDI rules read with the traffic data rules and guidelines provided by the Kerala High Court in relation to the Sprinkler app implementation aren't adequate as a protective net?
So again, I mean, and Divij, you can take this up too, that it's a good initiative by the Kerala government, and from adding on to the Kerala High Court sort of order, that they've come up with some protections. And what our bill tries to do is comprehensively cover issues arising out of these three challenges of exposure notification, contact tracing, and immunity passports, and give like a comprehensive legal framework within which your data protection rights will be protected. There will be transparency and then accountability.
So 43A does not cover government
Yes.
technologies or government processing of data. So that's out of the picture. It only covers body corporates. The Kerala High Court, as far as I remember, was only relating to overseas transfer of information. So the kind of whatever mandates or like rules it laid down there, again, aren't kind of universally applicable in these contexts because there's no overseas transfer. So I think that was kind of more specific to the facts of the Sprinkler case. And not kind of applicable to these contexts.
So an anonymous attendee is asking, does the Aarogya Setu protocol is not law? And considering purpose broadness seems to be a general trend in the Indian state's version of tech solutionism, is there a scope to empower a privately led collective application which can build trust? For example, can banks use this draft law to build/procure non-Aarogya Setu applications for contact tracing or monitoring? It does seem that there is some market demand for a digital health solution, but by default, most organizations are using Aarogya Setu.
I would just, if I may, Shashank.
Yeah, go ahead.
I think it would be very difficult for this to come out as a purely private solution without kind of the scalability that a government solution would provide. So even if you look at, and private people have kind of tried to develop this. I think the most famous, most widely used is, of course, the Apple Google exposure notifications, which is already kind of part of everyone's phones, which links up to any other kind of app as long as it uses a decentralized and privacy-preserving communications protocol and system. Aarogya Setu will not work with this. But essentially, yeah, this is a matter of scale, right? Scale or interoperability. If there are enough interoperable systems which are privacy preserving and allow individuals to build trust amongst each other, it's possible that something like this could work out. But yeah, I mean, I think it would be difficult without like formal state intervention, at least in the short run.
And also, if I understand your question correctly, our bill restricts a lot of the purpose for which you can bring in a technology and for the purpose for which such technologies can be used. So I'm not sure if our bill can, or our draft law can be used by banks sort of to, as your suggestion reads, to use kind of this framework. So yeah, don't think that will happen.
So there is a proportionality question from Siddharth, which is a bit complicated. It says that while strictly necessary could subsume proportionality, of course, since different judges have understood proportionality in different prongs of the proportionality analysis, could strictly proportional be added to strictly necessary within the text of the proposed legislation, since the conceptualization of necessity is understood differently in terms of varying degrees of intensity?
So, I mean, if I understood your question correctly, and our reading goes back to Medical Dental College, actually, where the Supreme Court comprehensively covered the sort of steps in the proportionality test, and laid down these sort of four prongs of, a rational nexus, then sort of least limiting measure of least sort of fundamental right restricting measure, and the measure having some social importance, and sort of such steps have been covered by and elaborately discussed by the Supreme Court in ranging on from Medical Dental College. They've just been discussing Puttaswamy 1, Puttaswamy 2, then we've seen other judgments of the cryptocurrency judgment and whatnot, and Radha Basin as well. So I think the proportionality test is pretty clear, and if you go through sort of our analysis, we've tried to cover that in detail as well. So yeah, I think using we don't need to use strictly proportional. I think incorporating principles of proportionality within the legal framework, which we've done, should be sufficient in our view. Divij?
Yeah, nothing particularly to add. I don't think, firstly, in both of these cases, the language of necessity has not been very clearly identified in Indian courts. So like you mentioned already, like it's a fairly broad term to use, and this is a problem with the PDP bill as well, that necessity isn't a very clearly recognized principle. I think it's similar with like proportionality and what it could mean in the context of a statute. Yeah, so I don't think it would be very useful. Ultimately, it will be something for judicial review, to a judge by whatever standards they decide to use.
Okay, Saket has a question that in reference to section 9(5), are there examples in other laws where a body such as a proposed oversight board itself appoints certain other members of that body?
I'm not you don't have to look necessarily to international circumstances. In a lot of Indian kind of say the National Human Rights Commission, where you set up an initial board which is then responsible for appointing other members of the same body. I mean, I know that there's significant precedence for something like this.
Okay, so last 5 minutes, there are 3 questions remaining. Siddharth asks, given that in the context of the pandemic, an ex-ante technology assessment may be difficult in every instance, what are your thoughts on subjecting the continuation of an existing implementation on the basis of the sanction from the oversight board? Perhaps a rollback along with other disincentives to implement in the first place could be considered.
Yeah, I mean, agreed with this sort of statement. I don't see a question there, but yes, that's what we try to recommend. If currently the form the bill is in, if it comes into sort of if action, then yes, the Aarogya Setu app will have to abide by all the protections and the purpose limitations we recommended in the legal framework.
Another question from Siddharth. How do you think the framework on non-personal data envisaged by the Gopalakrishnan Committee could potentially impact the non-personal data segment of the data collected or generated by these apps?
I think in the absence of a non-personal data sort of regulation / law, which is still the truth right now, I don't know if I think it's wrong for the Aarogya Setu protocol to sort of say that they'll be making use of non-personal data. We don't really have any regulation right now, and as that's being debated, we hope that some solutions come out of that debate on non-personal data, and then which are implemented in a particular regulation or law, which the sort of committee is also tasked to do. Divij?
Okay. Sure, go ahead, Divij.
Nothing. We did kind of have a deliberation about, how should we think about anonymized data or even non-personal data in this context, because it is valuable. Ultimately, there could be value in sharing this kind of information in anonymized fashion with researchers, right? But ultimately, it all boils down to, first, not just like assuming that all of this information is valuable and should be automatically anonymized and used. But if you're seeing that there is specific value in the information that you're collecting, that you think that the primary purpose of this kind of experimental technology is functioning, then you can start to see whether you want to use it for other kinds of research and other kinds of policy framing as well. So yeah, I mean, I don't think like non-personal data really should enter the picture, because there are other ways in which you can collect information, and experimental technologies in a humanitarian context is probably not the best way to do it.
So last question is from Mr. Deepak Maheshwari, who asks whether you've shared this with any MPs, especially members of the Standing Committee on IT or JPC on the PDP bill or the Standing Committee on Health. What's the feedback that you've gotten if you've shared it? Or what's the feedback you've gotten from anyone else if you've shared it with them?
For now, we've only shared it with a limited set of people, and we've gotten very good feedback from them. I mean, very not laudatory necessarily, but just very helpful feedback in our research. We have not yet shared this with any MPs. It would be great to kind of figure out more tactical ways and strategic ways to get this out to people who can action it. But definitely, I mean, we still think that it's important to have a lot of public input and kind of determine how this can go forward in a more inclusive way. Yeah, Shashank.
Okay, so there's one last question that just came in from an anonymous attendee. What would be the appropriate data retention period And does this draft legislation also have any sunset clause? That's my favorite question.
So I think, as we've recommended in our framework as well, the question on data retention needs to specifically come out from judging the efficacy and the way the app is structured in. The sort of technology assessment of the app needs to take into account that till what period the data needs to be retained specifically for the app to be useful. That is, I think, context specific to the kind of technology which is being used. Answering the question on sunset clause, I think, yes, we did deliberate on it, and currently the sunset clause in the protocol we feel is absolutely insufficient, because it gives the power to the government itself to review whether the protocol should go on, and also doesn't mention whether there should be like an end and a data deletion sort of stage after the protocol has ceased to be in existence. And yes.
Okay.
So,
Go ahead.
yeah, just to answer that specifically more, essentially the structure that we've done is that any such technology for deployment would require the sanction of the independent board, and the independent board has the power to withdraw that sanction. So because it's kind of a model of both sanction and continuous oversight, if the oversight board kind of feels that the technology is no longer necessary, then the sanction gets withdrawn. And the consequences of withdrawing that sanction, of course, is that you can no longer either use or process information through that and have to delete as per section 7 of this draft law.
Okay. Divij and Shashank, thank you so much for sharing your work with us and taking as many as 21 questions on this work. I hope this was as useful for you as it has been for us to hear you. So thanks, Shashank. Thanks, Divij, and Divij's cat, who made a fleeting appearance on a few occasions. Thank you all for attending. If you are watching this on YouTube, Twitter, or Facebook, please do subscribe to Media Nama. And if any of you worked on any research and you'd like to share it with us, please do get in touch with me. We'd be happy to talk to you. Thanks all, and please do give us feedback on this. This was the very first talk. I hope you found this interesting and useful. And we hope to bring more research to light, more work to light from people who are doing some very important work in technology